Madam Chair, members of the committee, Ian Huyett appearing for Cornerstone in support of OTPA on House Bill 1268. I would like to address the specific legal criticisms that I've heard of the bill so far, so I think I'll just go ahead and take a crack at that until my time runs out. There was a recurring theme that removing notification mandates will leave families more vulnerable to reports to and investigations by government agencies. And the most obvious and straightforward response to that is that there are a variety of different states, as Mr. Rodriguez mentioned, that have no notification requirements whatsoever. The closest one to us is Connecticut, and I've in the past worked with a variety of church communities in Connecticut, so I called them to ask them how homeschooling works there. And in Connecticut, no notification requirements ever on anyone. You could walk into public school in the middle of the day during the lunch period, pull your child out, never come back, never notify anyone, and just start homeschooling, and you've not violated any laws whatsoever. The homeschoolers there like that system. There's no push by the homeschoolers to institute mandatory notification in Connecticut. And to the extent removing mandatory notification could create vulnerabilities, those are more than offset by, in Representative Noble's bill, the strong affirmative protections she creates in the amendment and in the red text, especially A4 Roman numeral 5. A there, provision A under Roman numeral 5.
Are you referring to this outlines document, or are you referring to the?
Well, it's in both, but A4 Roman numeral 5 is in the amendment as well, the OLS drafted amendment. And provision A there, which because it mentions evidence specifically, the state may not use evidence of home education. I read that actually as an exclusionary rule that could be the basis for a motion in limine. So that's a good substantive protection. And particularly now, not in the amendment, but in the red text, Roman numeral 7 creates a strong civil remedy. And maybe I'll conclude by talking about that because there were a couple of claims that this civil remedy is not going to really be accessible to most homeschooling parents because they don't have the financial resources to use it. This civil remedy provides for reasonable attorney's fees if you prevail. Reasonable attorney's fees provisions are an excellent enforcement mechanism. They are routinely used in courts in a variety of different contexts. And they are one of the best kinds of enforcement mechanisms that can be used in New Hampshire. The alternative, this is sort of like crowdsourcing enforcement when you create reasonable attorney's fees. That means you don't need to rely on state agencies. You don't even need to come to a nonprofit advocacy group like Cornerstone. We'll just send you to the attorney down the street because they can litigate the case for you and they're going to get financially compensated. So they make a good crowdsourced enforcement mechanism. And the alternative traditionally would be to do something like entrust some state agency with enforcement. Such and such state agency shall enforce this or that requirement. And that may sound appealing on paper to an overworked homeschooling family, but my caution there would be we've seen bill after bill. Madam Chair, if I could fit in one more sentence, which says that a state agency shall do this or shall do that in order to enforce and implement some bill, and then the state agency just decides they're categorically going to refuse to even investigate violations of the bill. When you entrust a state agency, then you create the risk the state agency can nullify that law if the personnel at the agency are just not ideologically aligned with the goals of the bill. So crowdsourced enforcement is a great enforcement mechanism. I'd be happy to take any questions.
Thank you. Any questions?